So welcome to the First District Court of Appeals. We have a special set of arguments this morning, and I'm going to go through this and try to streamline it and simplify it as much as possible. So we have a set of cases that are going to be arguing this morning, which are cases number C180184, C180196, C180458, C180515, 0555, 0642, 0647, 0685, 0687, C190554, 0618, C200018, 019, 020, 021, 022, and 0205. And that encompasses plaintiffs Mike Sand et al., Robert Wilson et al., Andrew Carr, Teresa Robinson Woods, Richard Elliott, Rachel Jones, Deborah K. Rourke, Damon Deck, Ronald Schuster, Dolores Scott and Riley Scott, Deborah Kidd, and Timothy Osborne versus Durrani, Cast, Christ Hospital, and Good Samaritan. So this morning we have, as I understand, for the appellant, Attorney Statman.
Correct, Your Honor.
And I assume you're ready to proceed.
I am ready.
Okay. And then splitting time, we have for the appellee, Attorney Herzig, Attorney Mitchell, and Attorney Foley. Good morning.
Morning, Your Honor.
Good morning, Your Honor.
And I don't see Attorney Foley.
I'm right here, Your Honor.
Oh, I'm sorry. Okay. So I assume everyone's ready to proceed. And as I understand, and each side will have 30 minutes this morning. As I understand for the appellee, the 30 minutes may or may not be split. Attorney Herzig will be arguing first. If there's time left over, then Attorney Mitchell will be arguing. If there's time left over, then Attorney Foley will be arguing. Is that correct with regard to the agreement?
Yes, Your Honor. On behalf of Good Samaritan Hospital.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. Okay, Attorney Statman,
Yes.
whenever you're ready. And would you like to reserve time?
I don't think that I'll be using nearly the 30 minutes, but just in case, I'll reserve 10 minutes of my 30. But I think because the issue is fairly narrow, and my interpretation is such that it will not take very long for the appellant's argument. So would you like me to begin?
Yes, understood. Whenever you're ready.
All right. So again, this is Alan Statman on behalf of the Durrani appellants in this case. And I think that it's fairly clear that the issue is limited to whether the repose period in 2305-113 is tolled under 2305-15A. And this is not a case about a savings statute, it's a case about a tolling statute. And so does the absent defendant statute apply to the medical claim statute of repose? I believe the answer is yes. And it's yes because of the specific language of the two statutes. And it does not cause one to what I'll call bastardize the definition of any word in either of the statutes. So in looking at 113, it says no claim shall be commenced more than 4 years after the occurrence of the act or omission, but in this case we have the act, constituting the alleged basis of the claim. So what that does is it sets a bracket around a calendar which starts a 4-year clock ticking.
Well,
And-
and Mr. Simon, there's also some express exceptions to that. I think part of the thrust of the appellee's argument is there's no similar exception with respect to the abscondment statute.
I understand that. And as a matter of fact, I don't believe that there needs to be those separate exceptions, and I'll tell you why. Going next to the absent defendant statute 15A, 2305 15A, it says and incorporates within it other sections of the Ohio Revised Code that it applies to. And one of those is 113. Now, you don't need an exception in 15A if 113 already says it's applicable to, 15 says it's applicable to 113. So you don't need to enumerate it the way those two exceptions are listed. And if you look at the words of the tolling statute, it stops at a point where any part of a period within which the action must be brought stops when there is a defendant that's absconded, secreted himself, etc. It stops it. And when you look at the words, the time which the action must be brought, 113 has two time periods, 1 year and 4 years.
So the language you're focused on does suggest a kind of broader interpretation in terms of potentially encompassing the statute of repose. I think what, just to bring in the appellee's argument, they really focus on accrue, the use of accrue in Section A. So can you help us understand why that doesn't do what they say it does, which is, according to them, it limits it to statute of limitations?
Well, because the words of 15A talks about within which the action must be brought. It doesn't talk about any period of accrual. It talks about a period within which the action must be brought. That's a 1 year period or a 4 year period under the statute. In my logic, which I think is philosophical logic compared to some of the quote unquote logic that the defense wants to refer to, and I'll get to some of the things I find illogical about their brief. They don't want to focus on this language. They don't even want to talk about it. But the fact of the matter is that you can use the standard definition of accrual, which is, in essence, when a legal action is now available for a claim to be made. And so you've got the 1 year discovery rule, you've got the cognizable event, et cetera, all which fits into that definition of accrual. On the other hand, you've got the repose that says when the event occurs, that's the start of surgery. Under my interpretation of these statutes, and what I'm saying to you is you don't have to try to justify some other meaning of accrual. You don't need to justify some other meaning of when the action occurs. The action occurs, that sets the bracket. The accrual has to occur within that 4 years. In all of our cases, the accrual happened within the 4 years. Then 15A says that.
Let me stop you there for a second. Do we know, based on the face of the complaint, when the cause of action accrued?
We gave you a graph, a chart within the brief, and I can pull it up off my desk here, but that lays out the surgical date, et cetera, the lawsuit filing, and none of these cases, as I recall, were dismissed on a statute of limitations basis. It all had to do with the 4 year repose. So I think
that was an issue below, right? I think that statute of limitations was raised, and I believe that the plaintiffs argued that there wasn't enough discovery to determine when the accrual date was.
I don't recall specifically in each of the cases. I just don't believe that it came up through the system based upon a statute of limitations accrual argument that caused a one-year statute to run. That can still be open for another day. Certainly, it can be a factual issue when a statute of limitations starts to run, and we can figure that out, whether those statutes ran before flight or after flight by Dr. Durrani. My recollection is, I think most of these cases came about after he left in terms of accrual and obviously filing, but that is covered to some degree in the statute on flight, because within the brackets you have the accrual, but you have two discussions of accrual, which is flight occurs before the accrual, flight occurs after the accrual. Well, applying either of those within the brackets and then applying the plain language of 15A that talks about within which the action must be brought in terms of time periods, and knowing you've got the 1 year and the 4 year, the application of the tolling statute stops those actions, because it stops the running of a statute of limitation or the 4 years, because all of it occurred within that bracket. It's not like McNeil, which you've ruled on previously, where the action all occurred in 2012 and nothing was brought within the time periods that would apply under the defense point of view or my point of view. So in terms of looking at how this is bracketed and then how it accrues within the brackets and then the plain language of 15A, we end up with a tolled situation. Now, interesting, the federal courts that have looked at this all agree that the tolling statute applies. Now, the defense wants to say in their brief, or the appellee, that when you look at this from their point of view, the federal courts just glossed over the issue and they didn't do the 20-page deep dive that the appellees claim they did. I would submit that this deep dive isn't even remotely necessary, and it wasn't the federal courts not doing the deep dive. It was the federal courts realizing right from the language that this is an exception by its own terms, it applies. And
well, I guess what aspect of the federal court's decision would you point us to in terms of wanting us to follow from their statutory interpretation perspective?
You're saying what specific page or paragraph?
No. I mean, what is the thrust of their interpretation that you want us to follow, besides obviously the result?
My interpretation, which is they didn't need to go through this analysis because it would appear fairly obvious from the reading of the words that this is the logical conclusion that they reached. Some things don't need deep dives. Some things don't need to be overanalyzed. And
But here we have, the problem is now we've got the Wilson case, which is a very broad holding. And I understand it was dealing with a different statute, but it basically says there's no exceptions to the statute of repose. And I ask you how we would even get around that case.
well, it didn't say that exactly, and I'll tell you why. We wouldn't be here if that were the case. There would be no reason to remand this. The way I see what they've done was a jurisdictional issue, which is from the acceptance of jurisdiction on the appeal, they did not believe that this issue was squarely in front of them. However, if they painted Wilson with the broad brush that you're saying, there wouldn't have been any reason for remand, because they would have been able to say, hey, we're using Wilson because it relates to the statute of repose, even though it's a savings issue with a refiling versus a tolling issue within the same case. Well, we're saying no exceptions. No exception means no exception. No reason for a remand. It's eaten up within our decision in Wilson. And that's why Wilson may give you some obtuse reasoning to try to grasp from that case. But I don't think that it logically flows from Wilson that this isn't the reading. Because if my reading were incorrect and your statement about the breadth of Wilson was applicable, we wouldn't be here at all, because they would have been able to incorporate it into their finding and not cause this remand where they felt that they didn't have jurisdiction to do anything with this issue. And you guys haven't really touched this issue yet, and they haven't. And so I think that jurisdictionally, they couldn't take it upon themselves to paint it that broadly. And they're giving us, the appellees, and this court, the opportunity to paint it with whatever brush is appropriate from all of our perspective, and then ultimately your decision, and then visit it for the first time when and if it goes up. They may decide that you're so right, whether you decide for me or the other side, that they don't even accept it and they allow your decision to stand. That's yet another option, which I'm sure the appellees will say, oh, well, that will never happen, but it happens all the time. So I think the only thing we can predict from Wilson is they haven't ruled on this issue whatsoever, and they didn't paint Wilson broad enough to just say this is dead one way or another. Because if it were that, I think they would have said it, and we wouldn't be here at all. So I think my interpretation follows a logical progression of words have meaning and an application of those words, like I said, without having to twist and turn over what accrual means or when the action starts. Those all just have their ordinary plain meaning. Now, we talked about the federal court, but let's talk for a second about the pandemonium that the defense says will rain down upon the state of Ohio. Pandora's box will be opened. There'll be Armageddon. Let's talk about all of that hyperbole that exists in the appellee's breach in some attempt to scare the court into their result. It's nonsense. And the reason it's nonsense is that this statute was never meant, a repose statute was never meant to reward a fleeing accused felon who not only secrets himself, but having their passport confiscated, still finds a way out of the United States to a country.
Well, I mean, you're talking about the most egregious scenario, which is this case. I mean, the rule of law that we espouse here has to apply to every type of case. And I think the concerning part for me is it's not just an abscondment or concealment, it's also departing the state.
Right, but let's talk about that.
So my question is, are they right that if you go on vacation or you do something and you are departing the state, that stops the clock ticking? And how do we reconcile that in our interpretation?
Well, I think that they try to point, you see Durrani as one extreme. I see their position as a secondary, a different extreme. And the way that I reconcile it is, are we going to reward people that game the system? And what I mean by that is there are other days for further interpretation of what it means to leave the state. I don't agree that if you practice every day in Ohio and you live in Covington and you go home to live in your home that night and you come back, that we deduct 10 hours a night or add 10 hours to the repose period. There's no decision of any court related to what happens when someone's living their ordinary life in a spot that they come back into the state on a daily basis. That was one of their examples. And one of their other examples is someone that practices here for a short period of time for training, and then, for instance, moves to Iowa. Well, number one, there's a long arm statute which still applies. Number two, if they were in training, there is a respondeat superior argument, because typically a resident in training is an employee of a hospital, and you're going to have to bring that action in a way that honors all these statutes. And the question will be—
let me make sure I understand what you're saying. So you're saying, on the hypothetical of someone who's in medical school or in a residency, performs a surgery, does so negligently, suit is brought against that person. They have since gone to Kansas to start their career. Are you saying that the statute of repose is not told then?
No, I'm saying that is an extreme, the way you're saying that Durrani is an extreme, and that you're deciding in your hypotheticals that the statute wasn't meant to deal with the errant Durrani type defendant that commits criminal acts, civil acts, and then somehow gets out of the country to a country that isn't currently honoring an extradition treaty. That idea that someone trained here and then leaves the state and is facing this unlimited statute of limitations because the statute of repose is stayed, I don't think ultimately is an issue, because to the extent that they had an employer, which is where their coverage is going to derive from, because let's face it, this is a lot about insurance coverage as it relates to what the defense is trying to get to here, that they're going to have notice, they're going to have an idea that things are going on, because there is going to be an employer/hospital involved in this case. So it is far less likely that when they're 90 years old, they will suddenly be served with a malpractice claim from when they were 28 than it is another doctor following in the footsteps that Durrani sets as a precedent, decides, you know what, I got a home in Turks and Caicos. I can live there for 4 years and do research and submit papers and do other things until I'm out of these lawsuits. And I would say there are a lot more doctors that are going to take advantage of the Durrani path than plaintiffs who are going to file suit when students who committed malpractice are 11 or 12 or 15 years past the time, because the hospitals would have the same issue with record keeping, and they're not going to have it because they're going to be the employer. They're going to be sued within those time limits. They are most likely.
I guess I don't understand that part of your argument, because your client sued the hospitals too. So like, why isn't that sufficient for you?
Attorney Statman, just letting you know, you have about 2 minutes left of your 20.
Well, because these cases are cases directly against Dr. Durrani, and in terms of compensating the victims, we get back to the insurance issues, which is Dr. Durrani had his own policies because he was no longer in training. The hospitals in our case, with the exception of Children's Hospital, were answering because of negligent credentialing. In the children's case, it was because he was an employee at the time. And so this is an apples and oranges comparison. The hospital in the case of a trainee is an employer. A hospital in the case of Dr. Durrani, with the exception of Children's Hospital, is a credentialing hospital that gave privileges and falls under a completely different style of action. So my time is up. I've got my rebuttal time, and we believe that you should find the application exists for the tolling statute. Thank you.
Thank you. Attorney Hersey, good morning again.
Good morning. Good morning, Your Honors. Aaron Herzig on behalf of appellees Dr. Durrani and Cast. Just for the record, we are appellees in all of the cases listed except for Doyle, Nisbet, Smoot, and Walsh, which are consolidated under KID. We are appellees in KID. May it please the court, Judge Krause asked the most important question so far this morning because it's our starting point. How do you write around Wilson? Paragraph 38 of Wilson describes its holding. It explains very clearly that the medical claim statute of repose is a, quote, true statute of repose. Those are words that the court repeats several times in Wilson. You see them in Antune. The court means what it says. I think it's using the words true statute of repose to make abundantly clear that this is a strictly read statute. It then goes on to say, except as expressly stated in 2305.113C and D, the statute of repose clearly and unambiguously precludes the commencement of a medical claim more than 4 years after the occurrence or omission. It chose those words carefully. It emphasized them 2 sentences later. Had the General Assembly intended the saving statute to provide an extension of the medical claim statute of repose, it would have expressly said so. That is a clear directive from the Ohio Supreme Court that when courts are evaluating whether there is a tolling or extension or saving of the statute of repose, it should only look to the statute itself and look for express extensions.
Mr. Herzig, didn't the court draw a distinction between the saving statute issue there and a tolling concept?
I don't think it did, Your Honor. I think it simply was describing the particular statute in front of it. But the tolling case is actually worse for appellants. Justice Stewart and Donnelly, in their dissent, at paragraph 43, tried to distinguish these two things and say, look, the exceptions listed in 2305.113C and D are tolling or extending statutes. And so when we're reading the saving statute at the time, we shouldn't see as one accepting the other. So I think they have no room there. If these are, if you want to do the categories of tolling versus saving, the statute expressly incorporates tolling. Even the dissent in Wilson says so. So if those are expressly included as tolling statutes, how could you simply imply one? And I think the reasoning of Wilson.
Let me ask you this, Mr. Herzig. If you look at 2305.15B about the imprisonment scenario, would you agree that that tolls the statute of repose?
So that's not in front of us, and it's not an issue that obviously we've spent a lot of time on. I will say it doesn't use some of the words that indicate to you in A that the repose period is not implicated. It doesn't use the word accrual. So one could argue that it does perhaps apply more broadly, except for the fact that you still have to write around Wilson. I think this case really starts and ends at Wilson. As we gave you in our brief, though, we have a detailed analysis of why the language of 2305.15A still wouldn't apply even if you didn't have Wilson in front of you.
So let's leave Wilson to the side for a second, just focus on the language of the statute.
Sorry, Judge Bergeron, but before we put Wilson to the side and get into the language, because we need to get there, I just wanted to ask you about what Mr. Statman argued as far as why would the Supreme Court then remand this case to us to decide this issue if the Wilson case precludes us from deciding this issue?
Well, I think it's the common order of how the courts treat cases, right? That question wasn't before them jurisdictionally, although appellants did attempt to raise it in their briefing, and we ended up responding to it, and it wasn't decided by this court. Only one issue was decided by this court. That's the issue we raised to the Ohio Supreme Court. That's the issue they reversed on. And so they simply remanded to make sure that it's gone through the natural course of appellate proceedings. This is the same issue that came up in Antune. In Antune, they expressly said, we don't decide today the question that was Wilson. I think it would be a mistake for the court to read that as saying well, that means they were going to rule the other way because they didn't do that in Wilson, right? Antune left the question open, and yet Wilson follows Antune and follows the logic of Antune, as we argued in the Ohio Supreme Court and here, and made clear that the saving statute doesn't apply even in our circumstance. So I think it would be a mistake to simply say because an issue was remanded that the court has to move in one direction. That is not what that court said at all. And of course, it was asked to reconsider. It ends up doing the remand. It does not say, hey, by the way, we're modifying or changing any of the language of our holding.
I'm not saying that. I just think that just by virtue of the remand, they're leaving the question open. So we can't just say that we're bound by Wilson.
Just because a question is unanswered specifically by a court doesn't mean that the answer is obvious from a decision of the Ohio Supreme Court, right? It's simply, if they've laid down a rule of law, you're now applying it to a new situation. And I think there is only one application that follows the rule of law that they've laid down in paragraph 38. I think you'd be implying a great deal to assume that because they remanded, they are saying Wilson doesn't apply. I think you have to start with Wilson. Just as in Wilson, you had to start in Antune, and in Antune, you had to start with Ruther. The important thing with all of those cases, of course, is throughout the time that this court, the Ohio Supreme Court, has had the opportunity to look at whether the statute of repose means what it says, it said a couple things. One, it's a true statute of repose. I think they mean those words. They keep using them, and I think it has more import than some courts have seen. Number two, they have never found an extension, an exception, a savings clause. They interpret the statute of repose very strictly, and they tell us why in Wilson, as they did in Antune. It's because statutes of repose are supposed to cut off actions 4 years after the act or omission. That's what the General Assembly meant. That's what the words say. And that's what they have directed the courts to apply. I think it's also important that this is a conversation that the courts and the General Assembly have been having for decades now about what these statutes mean.
Well, right. And so I want to go back to my question about B, because you didn't quite concede that it applies to statute of repose, but you came close. And when the General Assembly specifically includes 2305.113 in B, I mean, what are we supposed to do with that? I realize that issue isn't before us, but as we're trying to interpret these statutes, we've got this section B that it seems to contradict the thrust of your argument.
I disagree, Your Honor. I think that all of the language of A talks in the language of limitations. The use of the word accrual, that's the language of limitations. Repose has nothing to do with accrual. As the court has said in Wilson, as this court knows well, the repose period can end before an action ever accrues. So using the words accrual doesn't make sense here. As we lay out in our brief, talking about when a case begins to run doesn't make sense because the statute of repose tells us already when a case begins to run at the act or omission.
So are you saying that an action can accrue after the statute of repose expires?
Yeah, well, in fact, it never accrues, right? What actually happens
is it only accrue within the 4-year period, not after.
Correct. So if you're talking in the language of accrual, you are talking in the language of limitations periods, because accrual and repose have nothing to do with each other. And to finish, if I may,
well, there's other statutes on repose periods, not in the medical statute of repose, that actually use accrue. So it's, I guess I see a little bit of a disconnect between saying accrue is strictly limited to statute of limitations based on how the General Assembly uses it elsewhere.
So I would say a couple of things. First, if I could finish answering your question, my only point on B, Your Honor, is that without the word accrual there, without some of that language about when an action starts, our analytical posture is a little different, is really all I was saying. I candidly don't know. I haven't spent the time that we would spend to investigate that because it's not before the court. As to this question, I think a couple things. One, again, you still have to start with Wilson. Two, 2305.15a I think is abundantly clear that it's talking about limitations periods, and the range of statutes that it lists there is limited to limitations periods. That's why they use the word accrual and the words about the time that the statute runs. The other thing that I think is really important, my colleague appellant talked about the 2305.16 and how that exception works. Well, here's an express statutory exception, and the court says apply that one in the medical repose scenario. If the courts were allowed to imply that a tolling provision applied to a statute of repose, there would be no need for the General Assembly to specifically list a statute that is a tolling statute that everyone agrees is a tolling statute within the statute of repose. The words except as to persons minority or unsound mind as provided in section 2305.16 would be surplusage if that's how you were supposed to read statutes of repose. So that's where I think it's also very clear. And when you look at the statute 2305.113C and D, the General Assembly makes very clear choices. It has detailed explanations of when something might be. If you discover something in the 4th year of the statute of repose, you can get another year. If there's a foreign object, you can get another year. They've made these very specific and detailed choices. And to suggest that you then could imply others, I think cuts against what they wrote. I think it cuts against what the Supreme Court said in Wilson.
Well, but it's not just applying others. I mean, if you look at A, they specifically give a range of statutes, which includes 113, and they don't carve out 113C. So, I mean, there's a lot of problems with these statutes as we're all wrestling with, but I mean, that seems to me a pretty clear indication that they wanted 113 to be covered by A.
Your Honor, I would say two things. One, again, in our view, it's actually quite simple. An application of Wilson means you no longer have to wrestle with this. They've drawn a bright line rule. But two, our whole point of our statutory interpretation of 2305.15A, dealing with the words accrual and the words begin to run, is to demonstrate that the range is really only talking about the limitations periods within those ranges.
And I understand your argument. I'm not sure if I agree, because it seems to me that when a cause of action accrues, I see that as more of a trigger than defining which, whether it's the statute of repose or the statute of limitation that governs everything it says after that.
I guess I respectfully, I agree that it is a trigger within the statute of limitations context, certainly.
Right. So, if it's a trigger, well, I think it's a trigger within 15A. So, I'm trying to understand how the trigger then now kind of delineates and makes a very narrow determination as to which portions of the enumerated sections actually apply to the total of the sentence.
Well, I think a couple things. One, Your Honor, again, in our view, the General Assembly wouldn't have used the words that you see in the statute of limitations context if it intended it to include the statute of repose. Two, they have specific inclusions that they've made. Specific items that do toll the statute of repose are listed in the statute. And so one lesson from Wilson and many other cases is that if they've included some things, you shouldn't then assume that they've included everything else, right? What you really should assume is that they intended only those tolling provisions to be included. And Wilson is very clear about that. So I think it's very plain based on the language that the General Assembly used and how the Supreme Court understands it, and has said to the General Assembly and the courts, hey, if you want to extend the statute of repose, say so in the statute of repose. Say so expressly, say so clearly, because otherwise the General Assembly and the Ohio Supreme Court understand statutes of repose to be absolute limits on the time period for which you can bring a suit. If I may address, appellants brought up
a quick question on this except as language. And one of the things I did not understand about Wilson is that the statute of limitations section has except as language as well. And yet they applied the saving statute. So how do you reconcile that? Because this language appears in both statute of repose and statute of limitations.
Your Honor, I think the Ohio Supreme Court was very clear that you reconcile those because statutes of limitations and statutes of repose serve different purposes, are interpreted differently, and a repose statute is supposed to be interpreted very strictly. We don't argue that if it didn't apply to repose or statute of limitations, these statutes would have no meaning at all. And the Ohio Supreme Court has been very clear that a repose period is to be strictly construed. And that's exactly what they did in Wilson. The saving statute continues to apply to statutes of limitations. It absolutely does not apply to statutes of repose. So I think it's the lengthy discussion they have of the difference between repose and limitations that answers your question. If I may address, and I do want to leave some time for my colleagues as well, if I may address the federal cases that appellants raise. We're not criticizing, Your Honors, whether the court did a deep dive or not. The court can issue a decision in one sentence if it chooses. The federal courts relied on pre-Wilson decisions. And, of course, they were all wrong in Antune. They all went your way in Antune. And the Supreme Court, not in Antune, excuse me, in Wilson. They all went your way in Wilson. The Ohio Supreme Court obviously disagreed there. So looking at pre-Wilson, what, excuse me, Your Honor?
You meant.
Thank you. So I think Judge Bergeron's question was, where's the analysis that helps us get around Wilson and helps us understand the statute? It's not there because those are all pre-Wilson cases or post-Wilson cases that simply referred back to the original cases from the Southern District and said, this is where our courts have gone. They essentially treated as stare decisis in those situations. So I don't think you're going to find a set of reasoning in those cases that gets you beyond Wilson. Wilson is the North Star in this case at this point, and I think the court has been abundantly clear about what it means. The appellants talk about gaming the system, as we've laid out to you all before. The reason this issue even comes up is because after filing 500 suits in Butler County, losing 4 of the first 5, they then dismiss them all, move them to Hamilton County, attempt to get them in front of a judge who will consolidate them all, to the point where the Ohio Supreme Court has to step in and say, no, that was inappropriately consolidated. So if we're going to cast aspersions and talk about folks gaming the system, I think it's important for the court to consider the actual facts of how these cases present themselves. Dr. Durrani was here in the United States when virtually all of these cases were filed. I think, Your Honors, I've hit on most of what I want to mention. You have our briefing on these issues. I do think, the other statutory interpretation tools all point in our direction. 2305.113C is the more recent and more specific statute. So if you're trying to fit in whether this 100-year-old statute or not works with this modern statute, you would, of course, look to the more specific and the more recent. I don't think you have to get there, but those are other points. Finally, Judge Bergeron, you asked about—
I think that ties into the point that I was making earlier, which is, yeah, the tolling statute is an old statute, but then the General Assembly went in and specifically cross-referenced to 113. So, like, I don't— that seems like a problem from your perspective.
I think if we were under B, Your Honor, I would have a harder case. I don't disagree with that. I also, but you also asked about some of the examples in our brief. Those examples, several of them come from case law. The Ohio Supreme Court in Johnson versus Rhodes said that a physician who went on a 10-day vacation all the way to Kentucky, a mile from where we all sit, those 10 days extended the statute of limitations. They're all limitations cases. There is no statute of repose case from the Ohio Supreme Court or federal courts. But a 10-day vacation told the statute of limitations. So if you decide to go with appellants on this, a 10-day vacation would apply to the statute of repose. There's no logical reason why it wouldn't. In Garber versus Menendez, Judge Sutton in the Sixth Circuit said that a doctor who retired to Florida, the statute of limitations continued to run infinitely against him because he happened to finish his career and retire to Florida. And that's an important example.
I guess on those points, has there been, if that has happened in the statute of limitations context and it hasn't created, chaos or this completely unworkable scenario, why should we think that applying that in the statute of repose context would, create the sky to fall?
Because the statute of repose is intended to end claims 4 years after the act or occurrence. It directly undermines the express purpose of a statute of repose. That's why the General Assembly has decided that these claims, for reasons of certainty and the like, that these claims should end. And in fact, statutes of repose are created in part to cut off discovery rules. There's specific case law, including, I think, the Southern Methodist University case in the U.S. Supreme Court that talks about repose periods affecting people who retire. The exact point of repose statutes is to end these claims eventually. And so while a limitations period has all kinds of exceptions, including the ones that appellants listed, discovery and things like that, repose statutes don't. It is the fundamental difference in the nature of these two things that answers your question. If you don't have anything else, I would like to leave some time for my colleagues. Thank you, Your Honors. We would obviously urge affirmance of the decisions in all these cases, which were dismissed on judgment on the pleadings.
Thank you. And that leaves 7 minutes.
Your Honor, Jennifer Mitchell on behalf of the Christ Hospital. I'll be brief because we did not file a supplemental brief on behalf of the Christ Hospital because these issues don't pertain to the claims against the Christ Hospital. But the cases in which we are involved, Carr, Kidd, Doyle, Walsh, Nisbet, and Smoot should be affirmed on the grounds that this court, or should be affirmed on the grounds that this court has ruled in all of the other cases that have been before this court, from Young to Jonas and all the other decisions that have been reached. I don't really have any other argument on the merits. Thank you for your time today.
Thank you, Attorney Mitchell.
Your Honor, on behalf of Good Samaritan Hospital and TriHealth Inc., we are in the same position as the Christ Hospital. The cases in which we have appeals are the Kidd and Elliott case. They are both strict statute of repose cases. I should note to the court that the case that the appellants have argued from the Landrum decision was a Good Samaritan Hospital decision where Judge DeLotte did grant our motion to dismiss in that case, as she did not believe it applied to Good Samaritan Hospital with respect to the fleeing issues that are before the court.
Thank you. Unless there's any other questions from the panel. Okay, thank you. Attorney Statman.
Well, counsel said if it were under B, he would have a much more difficult time. And why aren't we under B? It's obvious. He took off on bond and evaded the situation that would have led to his prosecution and conviction. Counsel uses the words very plain, obvious, bright line, very clear, abundantly clear, and then tries to say that my argument is based upon some implication versus an expression. And I think it is very plain, obvious, very clear, and abundantly clear that 15A expressly says that it applies, and the words expressly mean that it applies. And we think that when you take the time to contemplate the arguments, review the briefs, that you'll find in our favor. And I do appreciate your time and the ability to do this by Zoom. Thank you.
Thank you. Thank you to everyone for your arguments this morning. We will take the matter under consideration, issue you a timely decision, and we wish you all a wonderful afternoon and a wonderful week.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
We are going to move to Scott, Your Honors. Is that right?
Okay.
Okay. I didn't want to sign off. I didn't want to sign off too early.
Exactly. We're now with case number C180641, R. David Scott et al. Versus Durrani et al. So for the appellant, we have Attorney Sparks. Is that correct?
Yes, Your Honor. Good morning.
Good morning. And you are ready to proceed?
I am.
Okay. And for the appellees, Durrani, UC Health, and CAST, we have Attorney Herzig for Durrani and CAST.
Bring Your Honor.
And Attorney Hines for UC Health.
Correct, Your Honor.
Okay, thank you. Attorney Sparks, would you like to reserve time?
Yes, Your Honor. Probably just a couple minutes. I don't believe that I think I told the court earlier, we don't need 30 minutes aside for this case. There's much more limited issues. But if I could reserve a couple minutes, I'd appreciate
Well,
that.
this case is scheduled for the usual argument time, which is 15 minutes for each side.
Okay, Your Honor. Then 5 minutes, if you would.
Okay, whenever you're ready.
Your Honor, the appellants here, I represent, well, let me start. May it please the court, Robert Sparks on behalf of David and Missy Scott. The appellants here ask the court to reverse the trial court and remand this matter for discovery. We have adopted and incorporated the arguments of the appellants and Elliott on the absent defendant statute, and will not argue those separately to the court, although we do believe that the application, that statute applies to the situation here. There are a few facts that are important for Mr. Scott's claim. The three matters that I'm going to argue to the court this morning. Dr. Durrani absconded during the statute of repose for Mr. Scott's action, and his license had also been revoked during the statute of repose and before the Scott's action was refiled in Hamilton County under the saving statute. One of the issues that we addressed for this court that is different from Elliott and the other cases that the court heard this morning is that because Durrani was not a licensed physician at the time the Scott's action was filed, the Scotts have not made a, quote, medical claim, as that term is defined in the medical malpractice statute. And appellees, therefore, are not able to rely on the defenses set out in that statute. The General Assembly defines a medical claim to mean it's a four-part definition. It's a claim that's asserted in a civil action against a physician. And a physician, as defined in the statute, is a person who is licensed to practice medicine by the Ohio Medical Board.
I guess I'm having a little trouble following that argument, because I think if every time you had a doctor retire, pass away, decide they were done with the practice of medicine and wanted to be a lawyer or something, it would seem to transform all those claims into non-medical claims based on the logic of your argument.
Well, Your Honor, I think by the terms of the statute, it does. And as we just heard with the absent defendant statute, the hospital, in their brief, argued that it's a court's duty to apply the statute, not to rewrite it, even if there's a perceived omission. But here, Your Honor, this is not a case, as we know from an hour of arguments now, where we're dealing with a retired doctor. This is a case, the facts of this case are such that, we have a person that fled the country under threat of criminal prosecution, pending lawsuits, and had his license revoked for misconduct, not surrendered.
We understand that, believe me. But I think that the issue, and I was trying to make this point in the prior argument too, is that we have to, interpret the statute in such a way that we're interpreting it consistently, and it's going to apply in a number of different scenarios, not just the scenario where someone absconds and flees out of the country, but other scenarios where someone retires or just stops practicing medicine.
I understand that, Your Honor, and I think that if that's not the intention of the General Assembly in enacting in the language of the statute that they have on the books, then, Your Honor, they can fix that fairly easily, because the argument is that what the statute really says is that a physician means a person who was licensed to practice medicine at the time of the alleged act of malpractice. But it's not what the statute says. And if and the facts of this case are somewhat unique, and all of the Durrani cases are somewhat unique with the facts we have, and it can be limited to the facts of those cases. But it's certainly not a situation where we should be looking to rewrite that part of the statute that we feel the General Assembly might have otherwise not express what they wanted to express, because it defines a medical claim not as a right of action. You do not have a medical claim once you are the victim of malpractice, and or even once you discover that you're the victim of malpractice. You have a medical claim when you file that claim, when you assert that claim in a civil action. And at the time the Scots asserted their claim in a civil action, Dr. Durrani was not licensed.
Well, so then that also begs another question, like, can they even bring a medical malpractice claim at that point under your reasoning if he's not a doctor and if it's not a medical claim anymore?
Well, Your Honor, that is a good question as well, but I think that you do not have a medical negligence claim just because there's a statute. Before medical malpractice statutes existed, you had a right to sue someone for negligence and someone who causes you harm. And that is no different than here. It is just would be governed under a traditional negligence type of standard, just not with all of with the presence of the statutory scheme that's in place now in the medical malpractice statute. So I don't believe that just because that you have to have a medical malpractice statute in order to have a claim for someone who causes injury. So, Your Honor, we believe the statute is clear, that the Scots have not made a medical claim as that's defined in the statute because they have asserted their claim at a point in time at which Dr. Durrani was no longer licensed. Again, not because he retired, but because his license was taken. Your Honor, a second issue in our case is our assignment of error that the trial court abused its discretion in allowing the hospitals to amend their answer to include the statute of repose defense. The hospitals sought leave to amend more than 2 years after the action was filed. They sought leave after they had filed their answer for the first time, after refiling their answer months later, after filing a motion for judgment on the pleadings, then withdrawing that, and then refiling their motion for judgment on the pleadings. And when doing so, Your Honor, there was never an explanation given for the failure to assert the statute of repose defense. They now argue in their supplemental brief that amendments are allowed when a defense is overlooked or not known at the time. But they also argue elsewhere in this case and in the other Durrani cases that the application of the statute of repose here is clear from the plain language of the statute. If that's the case, they should have asserted it. This is not one where the hospitals just overlook the defense. This is not one case. There are hundreds of these Durrani cases, as the court knows, with a team of lawyers working these quite extensively for years. This was not a defense, Your Honor, that was overlooked. In fact, I would argue that the statute of repose was not viewed as a viable defense when they filed their answer. It was not until Antune was decided, after this case, the Scots case in particular, was refiled. The failure to assert the defense did cause prejudice to the appellants here, Your Honors. It stopped all the discovery in the case, any discovery that we could have undertaken. The only scheduling order in this case that was entered was after the appellees withdrew their first motion for judgment on the pleadings. And the hospitals do argue that the lack of discovery here, the fact that no discovery had taken place, is a fact that weighs in their favor in establishing or trying to establish that there was no prejudice. But there had been discovery in this case, Your Honors. The hospitals had discovery from Mr. Scott when the case was in Butler County. They had written discovery. They took his deposition. But a couple months after Mr. Scott gave his deposition, Dr. Durrani fled to Pakistan. Couldn't take his deposition then. His medical records were seized by federal law enforcement. His lawyer lost his license. So this state of discovery, Your Honors, was frozen after this case returned to Hamilton County, or was refiled, I'm sorry, in Hamilton County. It was stayed for months while we took a trip to the federal court for the defendants or the appellees here to try to attempt to establish federal court jurisdiction. It was stayed for months while Hamilton County tried to consolidate and organize these cases. And it was stayed for months more while the Supreme Court was looking for a visiting judge to handle the case. It went to Columbus for a while. That judge eventually recused herself. And then it was months more before a visiting judge was finally appointed. When the stays were lifted, the defendants refiled their motion for judgment on the pleadings and again argued that discovery was not necessary, and the court proceeded to handle the case in that manner. So the trial court decision to permit the hospitals to amend their answer without even an attempt to explain why its most crucial defense was omitted was prejudicial and abuse of discretion and should have been reversed.
Attorney Sparks, you have about 1 minute to reserve your 5.
Thank you, Your Honor.
Thank you.
We have also argued, Your Honor, that our fraud claims here are independent under Gaines versus preterm. In that case, the patient there was a misrepresentation made to the patient that the court considered was not prompted by medical concerns, but was rather an effort to cover up misconduct. That's precisely what we've alleged here. The representations made to Mr. Scott, a man who received 6 back surgeries over just a few years, were not for our allegations were not out of concern for the medical care of David Scott. It was part of a pattern and practice to commit fraud and cover up misconduct. For that reason, those claims should be considered independent, are not subject to the statute of repose, and should be remanded to the trial court for further proceedings. So, Your Honor, the appellants submit that the court should reverse a trial court and remand this matter. Thank you.
Thank you. Attorney Herzig.
Thank you, Your Honor. Aaron Herzig on behalf of Dr. Durrani and Cast. I'll be very brief. The court has ruled on the license issue at least once in Jonas versus Durrani, 2020 Ohio 3787. And we think your logic was correct there, and it should be applied here. As to the third issue that Mr. Sparks just raised, this court has numerous times now rejected the idea that these claims are anything other than medical claims, and the Ohio Supreme Court has never accepted jurisdiction despite having it raised with them about a dozen times. So we think the court should apply its holdings in those cases to this case as well.
Thank you. Attorney Hines.
Thank you, Your Honor. May it please the court, Jeffrey Hines on behalf of Westchester Hospital and UC Health. Just a few comments in response to the second issue that Mr. Sparks raised that are specific to my client with respect to the question of amendment. I think I'd like to start with the areas where there is no dispute between the parties here. And first and foremost, that is the standard of review that applies, which is an abuse of discretion. I think when you evaluate the facts and circumstances that apply in this situation, it is quite a stretch to say that the trial court abused its discretion in this instance in granting the motion to amend, particularly when you consider the liberal manner in which every court agrees Rule 15 is to be construed and applied so as to allow amendments freely. We've cited to a number of cases that support our position in our brief, and I won't reiterate them other than to highlight the language from the Ohio Supreme Court in the Hoover case, in which they stated that in the real world, failure to plead affirmative defenses will rarely result in waiver. And I think they were accurate in that assessment. Mr. Sparks did indicate that, and he's correct, that these cases were stayed for a number of reasons for an extended period of time. And there's no dispute there. I think all of that weighs into the calculus here and the analysis that was undertaken by the trial court. It may not have been the sole reason, but the fact that these matters were stayed for an extended period of time only limits the argument or reduces the effectiveness of this argument about prejudice.
Mr. Hines, let me ask you this. I am probably forgetting or jumbling this case with another one. Did your client, when they moved to dismiss prior to seeking the amendment, feature the statute of repose argument?
I'm sorry, can you ask one more time, Your Honor?
Yeah, when you all moved to dismiss, Mr. Sparks referenced your motions to dismiss that were prior to the motion for leave to amend. Did you feature the statute of repose argument?
Yes. So you mean the initial motion for judgment on the pleadings that was filed?
I'm sorry, judgment on pleadings, yes.
No, that's okay, Your Honor. Believe me, everyone's having a hard time keeping all these cases in order. The original motion for judgment on the pleadings that was filed by Westchester Hospital and UC Health was premised upon the statute of repose. It was withdrawn, and when the motion for judgment on the pleadings was renewed, it was at that time that the hospital concurrently added or sought, I believe, to amend the answer to include it. I mean, to say that they were surprised by the fact that this was coming is a bit of a stretch. I would also say that it's a little bit difficult for me personally to reconcile this argument of prejudice when they take no issue with the co-defendants raising the issue, when the co-defendants did it on the exact same timeline, in the exact same manner. In fact, even the co-defendants who filed their initial motion for judgment on the pleadings withdrew it and refiled it. So, and coming back to what I was saying before, the fact that these cases were stayed for an extended period of time, it's hard to understand how the court granting the motion to amend when it did in any way created prejudice here. I mean, theoretically, even if the hospital had filed its motion to amend shortly after it filed its original answer in this case, based on the timeline outlined by Mr. Sparks, in all likelihood, it wouldn't have even been addressed until close to the time that it was, for the reason that all of these cases were stayed. So, the whole purpose behind precluding amendment under Civil Rule 15 is to avoid prejudice and surprise at trial that cannot be overcome. This case was months from trial. There had been virtually no discovery done in the case. So from our position, not only did the court make the correct decision, it certainly did not abuse its discretion on this particular point. Yeah, unless there are additional questions, I think I'll just defer to my brief on the remaining issues.
Thank you. Attorney Sparks.
Thank you, Your Honor. Just briefly, with respect to Mr. Hines' comment about Jonas deciding this issue, it did not, and this court expressly said it was not deciding this issue. The facts in Jonas were different, so the court expressly reserved this issue that we have in our case. But overall, with respect to whether it is the absent defendant statute or how the General Assembly defined a medical claim, if this court interprets the medical malpractice statute as urged by appellees, the rule of this case will not be that conscientious, law-abiding doctors that retire, need not fear endless civil liability. Instead, if the court interprets a medical malpractice statute as urged by appellees, the rule of the case will be that you can commit malpractice, injure hundreds of Ohioans, get indicted by the United States, have your license revoked by the medical board for misconduct, and if you hide out long enough, the Ohio statutes will allow you to escape all civil liability for every act of malpractice committed. For those reasons, Your Honor, we believe that the trial court should be reversed. Thank you.
Thank you again, everyone, for your arguments this morning. We will take the matter under submission, issue you a timely decision, and have a wonderful week.
Thank you.
Thank you, Your Honors.